We want to welcome all of you and thank you for your presence. We have a terrific turnout today, both in terms of number and in terms of quality. And we would like to begin the proceedings by inviting President of the New York State Bar Association, Henry Greenberg, and Chair of the Families and the Law Committee, Susan Lindenauer, to be our first witnesses.
Good afternoon.
Good afternoon.
Good afternoon. Mr. Chairman, members of this distinguished panel, my name is Hank Greenberg, and I am the president of the New York State Bar Association. It is my privilege to represent our 72,000 members from across the state. I am joined today by a person who really needs no introduction and is no stranger to this panel, one of the most distinguished members of the civil legal services community for decades, and a hero of mine, Susan Lindenauer, who also the State Bar is blessed to have as chair of committees on family and the law. I thank you on behalf of all our members for this rare opportunity that we cherish to present testimony on behalf of the association regarding financial eligibility for appointment of assigned counsel in family matters. The New York State Bar Association has a long, proud, distinguished history of fighting and improving access to justice for those with limited resources and supporting efforts to assure that inability to afford counsel is not ever an impediment to securing high-quality, well-trained, constitutionally mandated counsel. Our association has played, continues to play, will always play a major role for our advocacy for increased counsel rates and for state oversight of indigent criminal defense. I think, as this panel knows, in 2018, the association adopted policy supporting state funding and oversight of mandated parental representation. Just like indigent criminal defense, mandated parental representation is vitally, critically, urgently important as constitutionally protected rights, the most sensitive protected rights, are at stake. Indeed, the New York State Constitution guarantees the right to counsel to indigent persons in matters involving fundamental liberty interests in the parent-child relationship. Family court cases determine life-altering matters, the most sensitive matters that humans can experience, those affecting the safety of children and parents and the integrity and autonomy of families. The focus of these hearings is to obtain the views of a wide range of institutions and individuals who play a role in the provision of counsel to parents entitled to counsel, in most instances in family court at public expense. The New York State Bar Association, respectfully, our views on these critically important issues, views which have been shaped and informed by the work and experience of our diverse membership who serve on committees and task forces, should, I submit, must be part of the discussion. My comments this afternoon are divided and address three discrete aspects of the issues that you will be focusing on. The first, the need for appointment of counsel at the earliest stage of a child protective proceeding or a potential proceeding, and thus for presumptive eligibility in these cases. Two, standards for eligibility, and three, screening. Turning first to early appointment and presumptive eligibility, I think we can all agree that timely access to counsel for indigent parents is of critical importance. Unfortunately, in some family courts, there are far too many instances when parents appear without counsel at hearings in which the court makes life-changing decisions, including whether to separate a child from his or her family or to continue such separation following an ex parte or non-judicial removal of a child by a local child protective agency. Standards issued by the Office of Indigent Legal Services, which in large measure mirror the standards developed by our association's Committee on Mandated Representation, call for access to counsel for parents at the earliest possible stage of a child protective proceeding. Our association standards for mandatory representation expressly require, and I quote, that counsel shall be available when a person reasonably believes that a process will commence that could result in a proceeding where counsel is mandated, close quote. Our standards also call for the establishment of systematic procedures to ensure that prompt mandated representation is available to all eligible persons particularly where a child has been removed by a government agency from the person's homes. Early access to counsel supports the goals of the Family Court Act. It gives litigants the opportunity to receive advice and counsel before initiating or responding to litigation. Also, early access to counsel supports the due process rights of parents and families and provides the court with more complete information upon which to make decisions. Therefore, it is important, it's crucial, that the timing of access to counsel be included in any reform of the parental representation system. An important legislative reform would be to require the appointment of counsel for the parent at the time of an application by a government agency for an imminent risk hearing rather than waiting for the first appearance of the parent in court. To accomplish this objective in child protective cases, there needs to be an established and consistently applied mechanism for determining the parent's financial eligibility for assignment of counsel at government expense. Our association's memorandum in support of state funding for mandated parental representation, which was prepared by our Committee on Family and the Law, which was adopted as the policy of our 72,000 member association just last year, calls for presumptive financial eligibility at the outset of these proceedings. This approach is also endorsed by the interim report of the Chief Judge's Commission on Legal Representation of Parents. Accordingly, we strongly recommend the adoption of a statewide policy of presumptive financial eligibility for parents at the outset of these cases. The second element that I wish to address, standards for financial eligibility. Effective and prompt provision of counsel to parents is crucial for one facing a potential loss of parental rights. Counsel should be assigned whenever a parent possesses inadequate income to hire an attorney. We must address the gross differences in determining financial eligibility between jurisdictions and even within a given jurisdiction. Fair, reasonable, neutral criteria for determining eligibility for assigned counsel that allow for discretionary factors should be established. Whether or not a parent's income or other resources are enough to retain counsel depends on a variety of factors, including jurisdictional differences, such as the cost of living and the going rate for counsel, as well as other income and resource-related factors. Now, while statewide criteria should be developed, actual determinations need to reflect the real world, the ability of the given individual who has a constitutional right to counsel to retain competent, high quality, and knowledgeable counsel. The determination of an individual's eligibility for assigned counsel must always be nuanced. There shouldn't be bright lines as to disqualifying factors. For example, ownership of a car could provide the necessary transportation to get a job in a community where there is no public transportation. Similarly, ownership of a home in which the parent has little or no equity should not be disqualifying. One factor that needs careful consideration is how to treat the income of one parent when there are two parents involved, and they may or may not have differing interests both with respect to their child or children and with respect to any income or property they have. Consideration should also be given to establishing a presumptive financial eligibility standard which could serve as a baseline for financial eligibility determinations, but not as a ceiling for determinations. Some have suggested utilizing the 250% of the federal poverty guidelines. Other possibilities include the self-sufficiency standard for New York State 2010, prepared for the New York State Self-Sufficiency Standard Steering Committee, and the interest on lawyer account fund standards, which builds in discretion and flexibility. All of these kinds of considerations should be taken into account. Finally, screening. In the context of indigent defense, the New York State Bar Association has supported the position that screening for financial eligibility is properly the function of the judicial system or of a third-party neutral and not of the individual attorney or institutional provider assigned to provide representation. We see no basis for adopting a different position regarding the assessment of financial eligibility of Parents and Family Court. Utilizing the provider of counsel, whether it be institutional or individual, to ascertain financial eligibility is unwise and imprudent because it promotes both actual and apparent conflicts and conflicts of interest. Where counsel is seeking to create a relationship of trust with their client at a time of high stress for the client, close questioning about financial matters may create distrust. Furthermore, depending on the nature of the financial relationship between the provider of representation and its funding source, the screening determination may add to the provider's revenues or strain its resources, creating other conflicts. In closing, on behalf of the New York State Bar Association, I want to thank you, Mr. Chairman, and colleagues, for this opportunity to address important issues regarding financial eligibility of parents seeking assigned counsel representation in proceedings in the family court. The issues are involved, as I know this panel understands, are complex, and the rights of the parents are fundamental. We, Ms. Lindenauer and I, and our association urge this panel to take the steps necessary to address these issues thoughtfully, deliberatively, and appropriately. Thank you very much.
Thank you very much for your testimony, Mr. Greenberg. This is the first hearing of the current cycle of family court eligibility that I will have participated in, but I participated in quite a few of the criminal eligibility public hearings that we undertook back in 2015. And one of the threads of testimony that I recall very well from that period was the discrepancy from county to county, and as I believe you testified, even within a county, but particularly among counties and between counties, having to do with just decades of local practice, having to do with financial assets or lack of assets on the part of a county, whether it's a wealthy county or a poor county, urban or rural. It was just so apparent that there needed to be a consistent standard, as you say, locally applied, most of all applied to individuals, not to robots. And behind it all was lurking the question of, if you have a consistent standard but you don't have a consistent source of funding to support the application of that standard, the unfortunate reality that legal help costs money, or just the reality, not unfortunate, just the reality of it. Do you have any thoughts about the assuming that the standards that we ultimately will promulgate will serve to allow access to counsel, assignment of counsel for some people who are presently deprived of that counsel, and that there will be a resultant cost, as to how this should be addressed in terms of state funding? I myself, I'm putting a bit of a leading question because I'm very concerned about the disparity in the application of consistent standards that will result if the source of funding is at each individual county level.
The State Bar has taken a position calling for state assumption of funding for both indigent defense and for representation of parents in child protective and other proceedings. We have policy to that, and we are prepared to proclaim that rather loudly.
Thank you very much. Other questions?
Sure. So I want to talk to you a little bit about the bar's position that upon the request by a child welfare agency for removal or protective order, that should trigger the right to counsel, or is it the right to assign counsel? Is that early enough? We have typically an investigation that's gone on before that request is ever made. And parents typically do not have counsel during that period of time. They don't have someone to advocate for them to the agency, to get them services, to propose alternatives to protective orders or removal. Is that early enough?
I would agree that if a parent becomes aware, and the parent should be made aware, of an incipient investigation, there should be a mechanism for that parent to seek counsel, much as there would be in any civil legal services program. There should be counsel, whether it is through an assigned counsel program or an institutional program available. In New York City, where most of the representation today is provided to respondent parents through institutional providers, they do step in to these proceedings before they are proceedings, when they are inchoate. And I think it would be important for this commission to try to develop a protocol for that. It is not the easiest thing to do, but I think it can be achieved.
And if I could follow up, to effectuate that, do we need a requirement perhaps by way of legislation that parents be advised of the existence of such assistance for them at the time that the need arises? And who would do that?
I would agree that you would need to have legislation to, in fact, make it possible for the parent to secure counsel even at the emergency stage, and that legislation could be expanded. There is a need. The Family Court Act, as currently written, does not provide counsel early enough for what we are proposing, and I think it could be redrafted in a way to reach the stage that you're addressing.
Thank you.
So I'm going to ask a question because I tend to focus a lot on process. And I'm wondering, as I think about all that you have said, which I agree with and I think are important considerations for us to take into account, if we also need to think about not just whether counsel would be provided early enough once the agency became involved, but maybe trying to make clear that we provide notice for individuals that have any interaction whatsoever with the agency, that there are resources available. And also the way in which those resources should be provided. Is it your opinion that perhaps that notification that we were just talking about should be provided in multiple languages because they're coming into contact with people who may not understand perhaps English, and so that they can be provided with substantive information that can be used?
Without question, due process does not exist if you cannot understand what is being said. Multiple languages, ability to provide meaningful notice to those with disabilities, whether they are visual or oral, is part and parcel of what is needed. Also part and parcel of what is needed is the ability, of course, to access services. Certainly the institutional providers of representation to parents, of which I'm aware, have social work staff and parent advocate staff. I think that all of that is part of providing counsel.
Thank you.
Any questions? Thank you very much for your testimony. Before I let you leave, I just want to thank President Greenberg for lending the stature of his office and his organization to this proceeding, to Susan Lindenauer for the leadership she has exhibited for so many years, and that fantastic report that I just reread last night for the Committee on Families and the Law that I was very pleased to see get through the House of Delegates in the executive process and become official NYSPA policy, and the association itself, which from the day we began operations in February 2011, through all the successive presidents and through the permanent staff, has been an essential supporter of the right to counsel for people who can't afford counsel generally, and specifically for the work that the Office of Indigent Legal Services and its board has done. We could not have accomplished what we've accomplished so far, and we will not accomplish what we still need to accomplish in the area of parental representation without your continued leadership, and it's very deeply appreciated.